Today we will be doing design. Yes, so please come to chapter number 20, design. My voice is perfect, right? Okay, great. Chodu sa chapter, don't take very much load of this chapter. Small chapter, we can do it very easily. So we'll study only 10 pages are there. Easily we can do it. Plus very easy also, not very technical. Like it's a very easy chapter. You have to study only how much we have marked. So please come to lesson number 20. Lesson number 20. Yes, all the girls here in the session. Yes, if any of your friends has not joined, you can ask them that our class have started and you can ask them to join. Yes, okay. Give me a second. Yes, so without further ado, let's start with today's lecture. And design, we'll be starting with design. I hope you remember the trademark, copyright, patent that we studied and you have not forgotten those topics. Yes, so in IPR, basically 5 types of IPR are majorly protected in India. Intellectual property rights, I have already taught you what is IPR, and I really hope that you have not forgotten all these topics, and all these topics are in your head, whatever we have studied, like what is trademark, what is patent, what is copyright. These 3 topics we have done. One small topic is left, that will do anyway, and I also remember one FTP small topic is left. Let's just keep it aside, we'll do it, don't worry. So IPR, intellectual property rights. Intellectual property rights are basically your those rights, those things which you have created from your brain by applying your intellect, by applying your creativity. So by applying your brain, by applying your intellect, creativity, something which you produce, that you have exclusive right to use that, and no one else can use that without your permission. That is known as IPR, intellectual property rights. So intellectual property rights example, we did trademark, copyright, patent. Two IPR are left to do. One is your GI, geographical indication, and then another is your design. Very short and sweet chapter. Trust me, I will not take much of your time. I will not take much of your time. I'll try to complete this chapter in shortest manner possible, and so that if one question comes of 5 marks or 4 marks from this chapter, we'll be able to grab it very easily. Very easy, chindi pundi chapter. Okay, so be very attentive. Be very attentive. I'm going to be a little bit fast. And in case you don't understand any topic, you can let me know in the chat box. I will clarify your doubt. Okay. Great. So basically we have done this three, and what we have understood is, if we make any new invention, like you new machine, new kind of machine you made, any new invention you made, so that you can get patent registration, that for that you can get patent protection. If you write any book or any artistic thing, like you have written any book, any literary artistic thing, you have made a painting, you have made a drawing, yes, you have made a music, so in all these things you can get a copyright protection, that if I have written any book, only I will be allowed to exclusively use it, no one else can use it without my permission. Okay, then we did trademark. Trademark is, name itself suggests, trademark means a mark or an identity which is kind of your brand identity, your brand name, which only you can use. Like if you have made a brand name called Nike, yes, Nike, if you have made a brand name called Nike, you have worked so hard to make this brand value, no one else should be allowed to use this name Nike and make profit in your name. So that we studied, that is your trademark, that is your unique mark, or you can say your unique identity, which helps you to make more profit just because of your brand name, like Apple. Are you understanding? Yes. So these three topics we have already done. Yes, keep on revising, keep on revising, keep on making, keep on doing cumulative revisions, short revisions, multiple revisions are very important. Otherwise theory subject will become very painful for you to study, so you have to revise it cumulatively. Make short notes or do the highlighting in your material and revise cumulatively. So trademark, patent, copyright. So today we'll be doing design. Now what is design? Design means, see, a small line I will tell you, you will quickly understand what is design. You will quickly understand what is design. One small line I will try to explain you. If I applied my creativity and I made some unique design of the product, for example, I made Ferrari. I don't know what is the yes, I made a unique, let's say Tarzan the Wonder Car. I made this Tarzan the Wonder Car. Or no, let's check Lamborghini. Yes, what is the spelling of Lamborghini? I don't know. Yes. Yes. Let's say I made this unique design of this car, the unique side, the shape of the car. Now this design, this unique shape of the car that I made, I don't want any other car brand to copy this exact same shape, or I don't want any other car brand to copy this exact design of my car, this unique design of it. It takes a lot of efforts to design a car model. Yes, so I made this unique car design model, and this car is very pretty, for the first time, I made like exact car looking car. Okay, so I made this unique design of the car. I don't want anyone else to copy this unique design. Then I can get protection. I can register this design under the design law. In India, we have a proper design law to protect this design. Remember, I told you, I gave you one example. Remember क्या, कोको कोला बॉटल एग्जाम्पल? बोलो ना, कहो ना, कह दो ना, कह भी दो. कोको कोला. How is Coca Cola bottle? Have you seen Coca Cola bottle? Of course, yes. What kind of question is this, ma'am? What is this behavior, Pooja? Yes, wait. I'll just try to make it that design. My hands are shaking because of the weakness that I still have. Okay. This is the Coca-Cola bottle. This exact shape of Coca-Cola bottle. We made a bottle with this kind of shape. Yes, yes, zero figure shape. So, and you know this design, the shape is just an example. It's not like only shape can be registered as a design. This design of the Coca-Cola bottle is registered under Design Act, which says that no one else can copy this exact same design. Now, please understand, design is something which you make out of your creativity, which is appealing to the brain, which looks beautiful. Like for it, it's only for looks, only for the attractiveness to the eye. It's for aesthetic purpose. For example, car. Everyone makes car with the four wheels, one steering, one gear, and one window. Sorry, window on the four sides and on the front. So, my dear, this are like basic feature of the car. This you cannot get design registration. These are the basic features of the car. Every car will have like four wheels. Yes, windows will be there, one gear, one steering will be there. But every car has this basic features. This cannot be registered as a design. Please understand, design means something which is, looks beautiful in your eyes, which looks beautiful to you, which is aesthetic for you, which is aesthetic. So you made a unique design, and that you made a unique design of the car which looks beautiful from outside. So any unique design, like the shape of the car, for example, you can say like this shape car we made, for example, this unique shape car like a crocodile, this unique shape car that we made, and this design of the car we can register as a design. Acha, can we register the basic feature of the car as a design under Design Act? No, we cannot do that. Remember, if you remember, I don't know if you remember or not, in face to face class I gave you one example. In face to face class I gave you one example, um, table example. Remember kya? Table, I made one beautiful table. Do you remember I gave you this example in face to face class? Yes, that, let's say this is table, this is table. Okay, huh, this is table. Can you register this design of the table as under Design Act? The answer is no. Why? Because this is this four legs and one flat top. One, what is there? One flat top. One flat top is there, and four legs are there. This is necessary for the functional purpose of the table. If any brand will make table, they will make table like this only. Four legs will be there. One top flat surface will be there. So this cannot be registered as a design. No, you cannot register this as a design. You can register only something, which unique thing you make, which is not necessary for the functionality of that product. Only that thing you can register as a design. For example, this basic feature, this basic functionality of table you cannot register. Ki I made this table with four legs and one flat top. Now no one else can make table like this. This you cannot get design protection for this, because this is necessary for the basic functionality of the table. All table are like this only, with four legs and one flat top. Now let's say I made a unique design of the table, unique carving of India map above the table, and some legs like this, and then this, and this unique design I made of the table. If you remember, I made this kind of table in class also. If you remember, yes, Pinky, do you remember? Yes. So this kind of table I made unique shape, unique design, unique looks. Let's say I use some different material for making this table, and I make this unique design of the table. Now can I register this as my design? Yes. Now no one else, no, every company who is making tables, they cannot make this exact same design table. Dresses are the very good example of design, I will tell you. Dresses, yes, dresses are the very good example of the table. I will just give you example. This nice dress, Sabyasachi, my dear, Sabyasachi का लहंगा, yes, मनीष मल्होत्रा का लहंगा. मैं शादी करूंगी तो किसका, करीना कपूर वाला डिजाइनर लहंगा पहन के करूंगी, वरना नहीं करूंगी. So my dear, this dresses you make, Sabyasachi and all these brands, they sell their dresses for so expensive, like crores, even crores of rupees. So let's say you made a unique design of the dress with a unique material, unique prints are there, unique shape, and a unique dress you made. You designed like all this dress designers. Yes, you designed Sabyasachi ka lehenga. Now, my dear, no one else can make that same Sabyasachi ka lehenga. Otherwise, that will be called as piracy of designs. Piracy. You know na Chandni Chowk, हाँ दिल्ली में चांदनी चौक सब चीज का कॉपी मिलता है. H&M का कॉपी, Zara का कॉपी. Yes, girls, every brand copy you will get there. What is that? That is legal? No, that is not legal. That is illegal. That is known as piracy of designs. Are you understanding? So this dress may, you make a unique dress, this you can get design protection. Now my dear, dress may, please understand that every dress is like this only, from top till bottom, like kind of gown. How gown, ladies gown is there, all girls are there, one boy is there, Kishan. I hope Kishan will understand. Yes, you might have a girlfriend, you might have brought dress for her. So all other girls are here, so girls will definitely understand. Let's take a gown like this. Now, gown may, please understand, you cannot register the shape. Why? Because every gown is like this only, from top till bottom. Every gown is like this only. But please understand, the shape of the gown, every gown will be like that only. That you cannot register as a design. For that you cannot get protection. But unique work that you do in that dress. Now that unique work we did in this dress, we made a unique floral designs here, and different pattern and different, I'm not a fashion designer, but theek hai. So this thing you can register as a design. Are you understanding? That is why all these brands products are registered. Louis Vuitton, yes, Gucci, all these brands ka, they design product, they design handbags, they design shoes, women ka shoes. Yes, shoes ka jo heels hota hai, that thing. And everything they design, and they get design protection under the Design Act. And my dear students, this is protected internationally also, because we have made our Indian design law inconsistent with the international trips agreement. International trips agreement ke according, international ke sath in consonance, we have made our Indian design law, which is made recently 2000 mein. ठीक है, right? So a few more examples I'll give you, like this. If you see this lamp, yes, if you see this lamp, my dear, please understand, the table lamp. Now table lamp will be like this only, the flat surface to keep on the table, and one lamp. That shape you cannot register as a design. That basic functionality of the table lamp you cannot register as a design. But if you made some unique table lamp, like you made some unique design, which is like this, which is like this, different lines, patterns, different lines you made, this kind of lines, and then this circle, and then this. So this unique design of the lamp that you made, this design of the lamp you can register under the design law. I hope you are crystal clear that what is design and what protection we can get under the design law. Very good example, jewelries. Jewelries are the very good example for design. You see lot of jewelries, like they don't allow you to take pictures and send. Why? Because of this piracy of design only. What if someone else will copy our design and make same jewelry, like tanishk Tanishk is making jewelry, let's say necklaces, bangles, gold, diamond jewelry, ring. Yes, all these things, these are design protected. No one else can copy exact same design of my necklace, which necklace Tanishk made. If that is protected under design law, no one else can copy that exact same design. Otherwise, so everyone will make same, copy paste same. And like for dresses, for fashion, women fashion and men's fashion, like all this, Bombay mein there is a street called, what is that street called, all the duplicate product street. जैसे दिल्ली में there's Chandni Chowk. Delhi में there's Chandni Chowk. Anyone from, अच्छा this is तो from Bangalore only ना. हाँ, I forgot. I thought this is my online class. So online class में तो students are from different places. So from Delhi also few students are there. Uh, yes. Uh, Bombay में, do you know there's one street? I forgot what is the name of that street. What is that street called? where all the duplicate products are sold, all the D first copy, second copy, watches का करोल बाग, नहीं तो करोल बाग इज तो इन दिल्ली ना, नहीं नहीं करोल बाग इज इन दिल्ली I guess so. Yes, Bombay mein there's one famous street. I don't know what is that street. Bombay. Let's search Bombay. I don't remember इसको. ठीक है, let's leave it. हाँ, याद आएगा तो बताऊंगी. ठीक है. So my dear, please understand the basic intention is you applied your creativity, you put some aesthetic, you put some aesthetic effect to make it beautiful. You made some unique design to make it look beautiful, like dresses ka design, like jewelries ka design, unique design you made of jewelry, unique kind of bangle you made. Yes, you can get design protection. No one else can copy that same design. If someone copies that same design now, then that will be called as piracy of designs. Piracy of design concept is also there. Chotu sa one paragraph is there in your material. Piracy of design. Piracy matlab, piracy means someone is copying your design without your permission. Like someone is making duplicate Gucci ka bag, someone is making duplicate Louis Vuitton bag or Zara dress, someone is making duplicate of first copy, second copy of let's say fossil watch, first copy, second copy, duplicate fossil watch, all this thing will come under piracy of designs. Are you understanding? Unique, your unique design of the watch we copied. Misho, huh? Misho, yes. Hill Road, Bandra. Nahi, I am talking about some other street. Hira Panna. No, 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 no. There's some other street. That name is not coming, but theek hai, I'll search it and I'll let you know. So the point is, this is known as design. So now, my dear, one more clarity I want to give you. Are you seeing this bangle? In this bangle, the bangle is of round shape. Can you register this round shape as the design? Okay, this is my design. No one else can copy this round shape. No. Why? Because that is the basic functionality of the bangle. Bangle will be round shape only. Please understand. So that round shape of the bangle cannot be registered as a design, but the unique creativity, aesthetic effect that you apply to it to make it beautiful. Now let's say to make it beautiful, what we are doing? We are doing like this kind of things here. We are putting some unique stones there to make it look beautiful, some unique design that we are making to it, to color combination, unique shape, unique linings, patterns that we are giving to it. All this thing can be registered as a design, which we are doing, by applying our creativity to make it look beautiful, aesthetic effect. That is important. The beautiful, why I'm saying, because anything you do to make a product look aesthetic, look beautiful, that you can register as a design, but the basic functionality of the product, that you cannot register as a design. I hope you got crystal clear what is design. I gave you a lot of examples of lamp. Dress is a very good example, very good example. And even Sabyasachi lehenga, Manish Malhotra lehenga, all these are design protected. Their design you cannot copy. And Chandni Chowk mein and all the streets mein, where you get the duplicate copy, the first copy of this lehengas, they are not legal, they are illegal. That is known as piracy of designs also. Are we clear with this? Yes. So this thing, basic thing I just told you what is design. So I hope you're clear practically, like what is design and what you can get protected under the design law. Yes. So law relating to design. History is given here. History is, I don't think so, very relevant from the examination point of view, but okay, I'll tell you what is given here. Earlier, first in India now, there was a same law for patent and design. Same law. So ऐसे में there was no confusion. Earlier there was same law for patent and design, which was Patent and Design Protection Act 1872, which was further amended, made in 1859, and then my dear, later on again new act came called Invention and Design Act 1888, and after that finally patent was separated, design was separated. So separate Patent Act 1970 was made and Design Act 1911 was made. So before this, now patent and design had a common act, like one single act. dealing with patent also and dealing with design also. Later on we segregated it. We made a separate law for patent and separate law for design. So first there was a same act, Common Act, Invention Design Act 1888. Then we separated, we made separate Patent Act 1970 and separate Design Act 1911. But that our Indian Design Act 1911 was not consistent with the international design law. So as you all know that we have made a WIPO. WIPO is an international body which deals with intellectual property rights internationally. You can get your IPR protection even outside India in other countries who are the part of WIPO. WIPO I have already taught you in the IPR chapter, first chapter. So we have entered into an international agreement with other countries, which is known as TRIPS agreement. This also we have studied in your IPR chapter. In the first chapter of this part 2, we have studied the basic international agreements, international bodies which are made to protect your IPR internationally. Question can come from that also, you cannot ignore that. That's why we have studied that chapter. Okay, so my dear, please understand that we have entered into an international agreement called TRIPS agreement, and in order to make our Indian design law inconsistent with the international TRIPS agreement, we made amendment, and this old Design Act 1911 was repealed, and later on new Design Act came and new Design Act 2000 came. Okay, so currently which Design Act is in force? Currently in India, Design Act 2000 is there in force, and as you all know, Act is just the skeleton. Act में all details, procedure, rules, regulations are not given. Act में just outer law is given, and Act are supported by rules. So in order to support Design Act 2000, design rules are made. So Design Rules 2011 came. Design Act came in 2000. Before this, there was Design Act 1911. But when Design Act Design Act 2000 came, then the old law was repealed. So currently we have Design Act 2000 read with Design Rules 2001. Are we clear with this? Yes. So this is like a basic thing. Introduction. Design refers to your creativity, your how beautiful you make a product. Yes, yes, it refers to your creativity. How creative I did some creativity, and I made a heel. I made a heels like this, women's heels, you know, and in which now, in the heels now, I made mountain heels में, वुमेन हील्स में नीचे जो हील्स होता है ना, वुमेन हील्स, फुटवेयर हील्स में नीचे आई मेड यूनिक माउंटेन कंचनजंगा, unique copy of mountain Kanchenjunga I made here in, and this design, this I made to make it look aesthetic, or you can say beautiful. So this, can I register as a design? Yes, this unique footwear design no one else can copy. Yes. You must have seen Namita Thapar in Shark Tank. She wears, my dear, so expensive shoes. Her shoes are like this design, dollar kind of design from bottom, so thin, and she wears this kind of shoes, and this they worth crores of rupees, this design of shoes of a particular brand. Now yes, so it applies to your creative activity. What is your design? Industrial design, you can say, it refers to your creative activity which results in some ornamental or appearance, formal appearance of the product. See, design is all about appearance. I'm telling you, design is all about appearance. How beautiful that product is looking. What is the appearance of that table? What is the appearance of that bottle? What is the appearance of that car, of that blanket? Let's say I made some blanket with some unique prints on the blanket. Even that unique prints which I made on the blanket, that can be registered as a design. Are you understanding? So that results in some please mute, Shushma, please mute. ऐसा मत क्या करो, I will get heart attack. Talking without muting yourself, don't do this. Okay, So, industrial design refers to a creative activity which results in some ornamental or formal appearance of a product. And design right refers to what is design right. Right means the official right that only you can use that design, no one else can use that design without your permission. Example, Sabyasachi made lehenga, Sabyasachi lehenga worth rupees 50 crore, for example. Sabyasachi made lehenga, and that Sabyasachi ka lehenga only Sabyasachi can sell or use, no one else can use that lehenga. Are you understanding? That is known as design right. Design right refers to novel or original design that is accorded to a proprietor of the validly registered design. Can we register design? Yes. And design ka registration is mandatory. One general knowledge I want to give you, which might not be there in your book, that in order to get design protection, design registration with government is necessary, with design authority. Without registration you cannot get protection. Even if, let's say, I made some unique design of blanket, the blanket, so unique design of blanket I made, and I did not get design protection, I did not register that design with the government, with the design authority. So now anyone can copy it? Yes, anyone can copy it. In order to protect your unique design, you need to get it protected by registering your design with the government, by registering your design with the design authority. That is one general knowledge I gave you. Are we clear with this? So here, design right you get when you register a unique design. Unique, novel means new, which is not copied. You did not copy that design from someone else, you made a new design. Novel design that is accorded to the proprietor of the validly registered design. Now which act was there earlier? You don't need to study this. And article 25 of the TRIPS agreement obliged every member to provide for the protection of independently created designs that are new and original. Not important from examination point of view, but ठीक है, one line I highlighted from here as well, that there is an international agreement, TRIPS agreement, and in that international TRIPS agreement, it is written that every country who's the member of that TRIPS agreement has to provide protection for the designs. Means they have to make a law and protect the designs which are unique and original. This page is not relevant from examination point of view. A case law is given here. If you have to, you can read it. Come to the bottom table. In this table, the primary object is given. What is the object behind this act? What is the object behind this law? What is the primary object of making this design act? The primary objective is to protect the shape, unique shape, and not the function. I already told you this. I have already explained you chilla ke that the main purpose of design act is to protect the unique shape that you make, the unique design that you make, and not the functional of the shape. Function of the shape. Are you understanding? For example, pencil. Pencil तो ऐसी ही होगी ना, like a single rod, single you can say small cylindrical pencil, this shape. Now this function, this shape of the pencil you cannot register. But if unique pencil, shakalaka boom boom pencil, unique pencil you make, that you can register. Dress may you made lehenga. Lehenga you cannot register as a design. That functions of lehenga, ki one blouse will be there, one lehenga will be there, one chunni dupatta will be there. That thing you cannot register. But if you made a unique kind of lehenga, designing of the lehenga with work and all, and that you can register. So the primary objective of design is to protect your design, protect your shape, not the function, not the functional shape. And the design does not include a method or principle of construction. Now design does not include method of construction. For example, Coca-Cola made a unique design of the bottle like this, and we registered, we got design protection for this Coca-Cola bottle. Yes, this is Coca-Cola bottle, and we got design protection for this unique shape of the bottle of Coca-Cola. Unique shape of the bottle of Coca-Cola, we got design protection. So design protection you can get for the design, not for the method of construction. Now how you made this shape, the process of making the shape of the bottle, that process you cannot register as a design. Design means simply looks, how this is looking, this design, okay, this we are registering, this is your design, no one else can use this design. But process of making that design you cannot copy. Are you understanding? So here one point is saying that design simply protects the unique design or aesthetic look that you make, which is appealing to your eye. It should be visible to your eye. Okay, but it does not include, design does not include method of principle of construction. Method of construction, how you are making that design, that is not protected under design law. Features of shape or configuration which is dictated solely by the function. If you want to protect something which is the basic function of that product, that you cannot register as a design. This thing I have already told thousand number of times. And which the article to be made in that shape or configuration has to perform. That's it. This is the basic purpose. A very important thing, very important. You can make a star mark here. The definition of the design, the definition of the design given under Design Act, very important. You can make a star mark here. It is defined in section 2 clause D. Section 2 clause D defines design, which says that designs means only the features of, only matlab only this thing is design, nothing else is design. Okay, so what is design? Design means only the features of shape, unique shape you make, that can be a design. Configuration means arrangements. Configuration means how you combine and arrange different small particles or small material and make a unique product. Pattern example, pattern, this pattern of blanket. Let's say you made a blanket and you made this kind of pattern, like this kind of flower, and then this kind of design, whatever design. Can you see this design? Is it, it might be visible in your book. This kind of designs is there, snake kind of, like a snake, and inside my flowers are there. So you made this unique pattern, you made this unique pattern. This pattern also you can register as a design. This car body, this car with this zebra body you made, this also you can register as a design. Are you understanding? So shape, unique shape, configuration, pattern, ornament, jewelry also, composition of lines, different lines, like in this particular car you made different lines, this kind of, this kind of, this kind of. Yes, this also you can register as a design. Color, different color combination, color or combination thereof, that also you can register as a design. But very important thing I'm going to tell you, listen very carefully, very important thing. In order to register any design as a design, it should be applied to a particular article. It should be applied to particular article. Now what do you mean by article? Article means goods. Articles means goods. And this line is very important, that it should be applied to any article. For example, this shape you are registering, this shape you want to register as a design. For example, this is the shape of Coca-Cola bottle. Okay, so this shape you want to register as a design. This shape you want to register as a design. Now listen very carefully, okay? This shape you can register as a design only for a particular product. For example, for bottle, for Coca-Cola bottle, beverage, let's say beverage ki bottle. So you took a product, beverage ki bottle, and that bottle mein you are applying that design. So if you are going to government, let's say I'm going to government, I'm saying government, I want to register this shape. I want to register this shape as the design. So government will say, Arey bhai, this shape you are applying to which particular product? What is this? What is this? Zero figure? Or what is this? What is this? Which product you are applying this shape? To which product you want to register this design? So I will say, acha, that you are asking, huh? I want to register this design for bottle, for bottle, for bottle. Drink ki bottle, soft drink ki bottle. So I want to register this design for a particular product. I want to register this design, this design which I have made, this design I want to register for which? For soft drinky bottle. So no other soft drinky bottle company can use this exact same design. Acha, but let's say I'm making body lotion. Body lotion I'm making, can I make a similar bottle? Yes, I can make similar bottle. Are you understanding? But any Fanta can make similar bottle kya? No. Pepsi can make similar bottle? No. Yes, are we clear with this? Everyone, are we clear with this? That design you can register only when you apply that design to a particular article. Article means goods. Example, dress ka. ड्रेस का सब्यसाची का लहंगा, you made सब्यसाची का लहंगा, that लहंगा design you are registering for a particular product. What is the product? The product is lehenga, women's dress. I'm really sorry. Yes. Okay. Yes. Are you understanding ki dress ka design that you are registering, that design you are applying to a lehenga, and you are saying that, okay, I want to register this design, this lehenga ka design for a particular product, which is women's ka clothing category. Women's ka clothing category, I'm applying this design to a lehenga. So it is very important that in order to register any design as the design under Design Act, it should be applied to an article. I hope this is more than crystal clear to all of you. That what is design? Design only means the features of shape, configuration, pattern, ornament, composition of lines, color or combination applied to a particular article, whether 2D or 3D. Now it can be either two-dimensional or three-dimensional. Two-dimensional means you are simply making that design on a piece of paper. Three-dimensional means you actually made that product. Three-dimension is mostly relating to, shape of the goods. Like you made a bottle. You made you made a bottle with a shape, and now you want to register that bottle, that shape of the bottle under the design law. So that will be called as 3D. So it can be either 2D or 3D. It can be either two-dimensional or three-dimensional. 2D or 3D. General mein to you know now what is the meaning of 2D and 3D. Or in both forms. By an industrial process, very important, very important, very important. By an industrial process, that design how you are making, ऐसा नहीं है कि बस माटी लिया, माटी को ऐसे शेप दे दिया और वो बन गया. You cannot register a design which is very easy to make. Are you understanding? That should be made by some industrial process, by some factory, by some industrial process. You made a unique printing on the blankets. Yes, you made a unique shape of the bottles. Yes, so some by applying some industrial process you are making that unique shape. So that unique shape or unique design should be made by any industrial process or means, by any industrial process or means, whether mechanical, manual, chemical. Even if it is handmade, that's fine. Handmade zari ka work is there na zari ka work, handmade work in clothing and all that. Also you can get Priyanka Chopra ka wedding gown, that was all handmade. All the work was done handmade. So it can be manual also, mechanical also, chemical also, separate or combined. ठीक है, which in the finished article appeal to and just solely by the eye. I told you, which is appealing to your eye, meaning it should look beautiful, it should have some aesthetic effect, it should be appealing to your eye. Your eye, by watching that particular design, you should be like, huh, this is unique design, this is different design. Yes. No, it is not a common design which is appealing to your eyes, where this is mentioned. This is mentioned in the definition of the design given under his design law. Okay, so as per section 2D, design means only the features of shape, configuration, pattern, ornament, composition of lines, color, combination thereof applied to an article. Very important, applied to an article, whether 2D or 3D, by any industrial process, or means whether manual, mechanical, chemical, separate or combined, which is which appeal to or judged solely by the eye, which appeals to your eye, or which is judged solely by your eyes, but does not include, very important, few things are not included in design. Sometimes they might even ask the definition of design only in your exam for 4 marks or 3 marks. Yes, it might be possible that they directly ask you what is the definition of design, or is this design or not, right? So this definition you have to by heart as it is. Okay, but does not include any mode or principle or construction or anything which is in substance a mere mechanical device. Number one, which is a principle or mode of construction. I already told you the method of constructing that you cannot get design protection. Like bottle ka shape you can register as a design, but method of constructing that process of constructing that bottle ka shape cannot be registered as a design. So it does not include the mode or principle of construction. Okay, or anything which is a mere mechanical device, like a mere functionality, like ghadi mein, or clock mein, of course 2 hands will be there, 1 hour hand, minute hand. Now you made 1 hour hand, 1 minute hand. Can you register this design under the design law? No. Why? Because this is necessary for the functionality of the clock. दिस इज अ मियर मैकेनिकल डिवाइस कि क्लॉक में 2 हैंड्स तो विल बी देयर ना, आवर का हैंड, मिनट का हैंड विल बी देयर. Now if you are making this hour ka hand, minute ka hand, this you cannot get as a design protection because this is necessary for the functionality of the clock. Everyone will make clock like this only. This is necessary for the functionality of the clock. So mere mechanical device you cannot register as a design. Mere mechanical device you cannot register as a design, and also it does not include trademark under Trademark Act or any artistic work under Copyright Act. Please understand, trademark is not included in design. Design is separate, trademark is separate. And artistic work के लिए you get copyright protection under Copyright Act. So copyright is different, design is different. Please understand that design is different, copyright is different, design is different, trademark is different. Trademark and copyright cannot be considered as design. I'll just give you one small example. Small example. Ferrari का shape of the car, yeah, that is the unique design of the product of the Ferrari, that you can get design protection. But Ferrari का logo, Ferrari का that yellow color का वो जो logo है ना, Ferrari का logo, that logo of Ferrari is for the identity of Ferrari. By seeing that logo anywhere, people will understand, ha, this is Ferrari ki car. Are you understanding? So that logo which is used for the identity of Ferrari is trademark. But the unique shape of the Ferrari car which no one else can copy, that is design. Are you clear with the difference between the design and the trademark? Because trademark you use for your identity purpose, for brand identity. For that purpose we use trademark. What do you need?
My charger.
Which charger?
Realme X3 Super Zoom.
I don't. It's there in the room. Okay. So sorry. Where was I? Trademark is different. Trademark cannot be registered as a design. Trademark is different, design is different, and copyright is different. Copyright is different. Design is different. That is why here it is given that it does not include. You can see here. It does not include trademark under trademark law, and also here also you can see it does not include any artistic work. You can see here artistic work. Can you see here artistic work? Yes, it does not include any artistic work which is registered as a copyright under Copyright Act. With this we are done with the definition of design very बहुत detail में. Now artistic work, what is artistic work? We already know, we have done the whole copyright chapter. Artistic work means any painting, sculpting, drawing. You can see here painting. Yes, painting, sculpting, drawing, work of architecture, other work of craftsmanship, all these things are artistic work. Artistic work are copyright. If you get protection under copyright, then you cannot get protection under design. If you get protection under design, you cannot get protection under copyright except for few exceptional cases. Please understand, you can either get protection under copyright or you can get protection under design. You cannot get protection under copyright and design both. You cannot get protection under copyright and design both. You can either get protection under copyright or you can get protection under design. Only few exceptional situations are specifically given. Few exceptional cases are given where you can register a particular product as a design also, as a copyright also. Apart from that, you can either get protection under copyright or under design. So artistic work, we already know, artistic work mein you get copyright protection. Now here in this paragraph, na, difference between design and trademark is given, which I have already explained you. Is particular paragraph mein difference between design and trademark is given, which says that design or pattern covers the whole body or the goods or the formal part of the goods. What is design? Design are the part of the goods. They are the part of the goods. They cover either the whole body or they cover the goods. They are the part of the goods. However, trademark, but a trademark, see in the second line, but a trademark is apart from and different from the goods for denoting the goods to be manufacture or merchandise of a particular person. Trademark is used to show that this goods belong to particular brand, this goods belong to particular person, this goods belong to particular merchandise. Are you understanding? Yes, yes, yes. So I just gave you example of Ferrari. That shape of the Ferrari car is a design. Design is a part of goods only. But trademark is something which is used to denote that this goods belong to this brand. Like Ferrari ka logo. If we use Ferrari ka logo in that car, it will use to denote that yeah, this car belongs to Ferrari. So that is the difference between design and trademark. Yes, next, an article. What is article? Article means any goods which you manufacture. Example, bottle, car, bottle, phone, any design, any unique pen ka design, anything. Yes, this article means any goods जिसमें you make design. So article means any article to manufacture any substance, any artificial or partly artificial or partly natural product. Any particular product which you manufacture is known as article. Article means any product which you manufacture. Yes. Now last paragraph you can see here, below the table you can see here, design is one of the category of IPR which focus on aesthetic feature. I have already told you, design focus on aesthetic feature. Aesthetic means how beautiful you can make by your uniqueness. Okay, so design is something which focus on the aesthetic feature of the article derived from its visual appearance. Visual appearance means something which you can see. Design ke liye it's very important कि it is visually appealing to you. Visually it looks beautiful to you, or some unique design you can see. So it is very important, it comes in visual appearance. Yes, so that is why it is appealing to your eyes. It is some beautiful, some aesthetic feature. So that is design. I hope you are crystal clear with what is design. Some examples of designs are given here. Come to the next para. Now I have explained you basic what is design, and next topic is very easy. No need to study everything. Just next topic, listen very carefully. One time you will understand. Proprietor of design. Who will be called as owner of design? Let's say I made a design. So who will be owner of design? I will be owner of design because I am the author of design. I made that design. Na? I made a unique design of the car. So I am the author of that design, and I will be the proprietor. Proprietor means owner of that design. Only I can use that design. No one else can use that design without my permission. So who is the owner of the design? Who is the proprietor of the design? First, see point number 3, author. Author means the person who made the design. Yes, the person who made the design. Give me a second. Okay. Yes. Come here. Author of the design. Why is this not working? The author of the design is the uh, owner or proprietor of the design. Number 2, sometimes you make design for others on the payment of consideration. Let's say I am hired as a designer for Sabyasachi. I am hired as a designer for Sabyasachi, and I am helping Sabyasachi in making a design. Okay, but I am paid money for that. So I made one design for Sabyasachi. I sold it to Sabyasachi and I got some money for that. So now that design, who's the owner of the design? Me? No, I have already sold that design for a lawful consideration, for a good consideration. I sold that design for money, for consideration. So I sold that design to Sabyasachi and I got money. So now that design belongs to Sabyasachi, not to me. So secondly, who is the owner? A person who purchases that design for valid consideration, that person also becomes the owner of the design. So if I made a design of the car and I sold that design to Ferrari, I'm an employee in Ferrari. I sold that design to Ferrari. Now who's the owner of that design? Ferrari is the owner of the design and not me, because I sold that design to Ferrari for good consideration, for money, for payment of some money. So read first wala point. First wala point mein it is saying that when the author of the design for good consideration executes the work, good consideration matlab money ke exchange mein, executes or sell the work, executes the work for some other person, means in that case the person to for whom the design is executed, you are making the work, you are doing the work for some other person on the payment of consideration. I am making a design for a brand. I am making a design for a brand, I am making design for Zara on payment of some money. So that design belongs to Zara and not to me. This is first point. Second point mate is saying that if I lawfully assign my right to someone else, let's say I made a design, I lawfully assigned that right to use that design to my brother also. Lawfully I assigned my right of ownership to my brother, then my brother will also be considered as a proprietor or owner of the design. Or let's say Mr. A made a design, Mr. A was the owner of a design, Mr. A died, so automatically his rights or his design rights will transfer to his legal heir. That will then his legal heir will also be considered as the proprietor of the design. That is given in point number 2. Point number 2 mate is given any person to whom the design has been devolved. Devolved means transferred, to whom the design have been transferred by the operation of law or by any other means, you can say. So where any person acquires the design or right to apply the design in any article, either acquires either the design or right to apply the design in any article, either exclusively of other person or otherwise, in respect or to the extent in which such design is so acquired, the person to whom the design is to whom the person by whom the design is so acquired, means if any other person is acquiring the design or the right to use that design, that person will also be called as proprietor of the design. Simple example, I made a design, I transferred the right to use that design to my brother, then my brother will also be called as proprietor of the design, the person to whom the design is transferred. Yes, or the person by whom the design is acquired, example my brother. And lastly, author of the design. Author means the person who's making the design. Author of the design will also be considered as the proprietor of the design. Are we clear with this? And where the proprietor, ignore this thing, these three people are the proprietor. In case question comes, you can write this one by one. Who is the proprietor of the design? Proprietor means owner. Number 1, author. Number 2, if I have executed the work for someone else for consideration, then that's some other person. Number 3, if my right is transferred to someone else, then the person to whom the right is transferred. Are we clear with this? These 3 person are called as a proprietor. Very easy. These 3 person are called as a proprietor of the new or original design. In case of any doubt, you can put it in the chat box. Please let me know if you are clear with this. Who is the proprietor of the new design? Yes. Next, this topic is also important. You can do a star mark here. My pencil is not working. You can do a star mark here. इसको बीच बीच में कुछ कुछ होता रहता है. Charge, so it is. Yes. You can make a star mark here. यहाँ पर. कहाँ पर? कहाँ पर? यहाँ पर. Here. Here you can make a star mark. Prohibition of registration of certain design. Certain kind of designs cannot be registered. Very easy, no need of explanation. Point number 1, which is not new or original. Only when you make a new design, that can be registered under design law with the design authority. If you have copied someone else's design, you made a duplicate Sabyasachi ka lehenga, that cannot be registered. So number 1, section 4, very important, prohibition of registration. This 4 kind of designs cannot be registered. Number 1, if it is not new and original, means you have copied someone else's design. Number 2, it is already disclosed in public anywhere in India or even outside country. That design was already there in public. That design was already there in internet. That design was already disclosed to public. Public already knew that design either in India or even outside India. In that case, that design cannot be registered. It has already been disclosed to public anywhere in India or even outside India. Point number 3, it is not distinguishable from other design. That is not unique. Means you made a design which is pretty common, which is like other design only. Something unique you did not make. It is not distinguishable. Something which is not distinguishable from other design. And lastly, 4th point, something which is scandalous or obscene. Any obscene design you make, let's say some obscene means offensive. Any offensive design you made which is offensive to a particular community, in that case, that design will not be registered. If it is scandalous or obscene. So very important and very easy. Very important and very easy. For 4 marks, they can ask you seedha in examination that which 4 kind of what cannot be registered or what are the prohibition of registration on design. Very easy. Free ke marks, Balaji ke marks, very easy, 4 points. This 4 things cannot be registered. Are we clear with this? Yes. So that same thing is given in this case law. In one Supreme Court, in one case law said that in order to register your design, it should be new. It should be new, matlab it should not be published anywhere already. It should be your unique invention, your unique creation. Yes, which has not been reproduced anywhere or which has not been published anywhere. Then only you can register that design. This case law is not important. You can just have a read over it. Prohibition of registration of design, that's it. Application procedure for registration. So you can see here this table. Application procedure is similar only for the trademark, copyright, patent. Application procedure is very similar. Let's say I made a unique design. Let's say I made a unique design of TV, for example. So I want to register that unique design. I made a unique design of dress. I'm a fashion designer. And I made some unique design dress. I want to register that unique design with the patent authority. Acha, you know, in India, the design authority and patent authority are same. They are known as controller of design and patent. Okay. So the controller, the authority, the patent office, same office is there for patent and design. They take care of the patent registration also, and they take care of the design registration also. So you have to file an application to the controller of the patent and design, and that application has to be in a particular form, and the form is form number 1. So you have to make an application to the controller in the form number 1. That has to be numbered, dated, and along with 4 copies. You can write here plus 4 copies. Now pencil started working apne aap. Bhoot is there. Yes, 4 copies के साथ numbering and dating करके you will submit, and then controller will examine the application and then publish it to public for objection. Now 2 cases can be there. No objection is there. If no objection is there, in that particular case your application will be accepted. After acceptance, it will be notified in the official journal. There is an official journal, official website. Yes, in the official website it will be published, and you will be issued a certificate of registration. Yes, certificate of registration. However, if objection is there, then people will communicate their objection. Sunwai hearing will be there of both the parties. Yes, and if you don't comply with the objection, your application will be abandoned, cancelled. If you don't comply with the objection, if examiner or controller raised any objection, and you don't comply with the objection, in that case your application will be cancelled, that is abandoned. However, if you do compliance with objection, in that particular case you simply controller objected, gave some objection, and you complied with the objection. In that case your application will be accepted and published in the official journal. You will be issued certificate. However, let's say if you raise further objection ki no, this objection is not acceptable to me, in that case hearing of both the parties will be done. After hearing, 2 things can happen. Either they can accept or reject. Let's say they removed the objection. Now they don't have any other objection. They accepted our application and they removed the objection. In that case, they will accept the application, and then after acceptance, they will publish it in the official journal and issue the certificate. However, if they refuse, they still object and they refuse to our application, in that case they will refuse or reject the application. Then you can file an application, appeal to the high court. Now high court can either allow or reject. In case high court allow, then your application will be accepted and published in the official journal. So basically here one point is given. You file an application to the controller, they will do the examination. If no objection is there, simply your application will be registered. If objection is there, 3 things can happen. 3 things. You don't comply with objection, seedha application abandoned, cancelled. You complied with objection, register, accepted. However, if you further objected ki nahi, this objection is not acceptable to me, then hearing will be done. After hearing, 2 things can happen. Either they can remove the objection and they can register, or they can refuse the application. Very easy procedure. This is a procedure of registration of design with the controller of the design. Are we clear with this? Now Come here, section 5. Not very important, same thing is given here. What is given in the table, you can just have a read over it. Application for the registration of design, section 5. Here one point is said that the controller may, on the application made by any person claiming to be the owner of the design, register the design. Who registers this in design? There's the controller of patent and design. I already told you, single controller is there for registering the patent also and for design also. Okay, so the controller may, on application made by the proprietor. Who can make an application? Proprietor of design can make the application. Now, who's the proprietor? That we have already done. Who's the proprietor? Okay, so proprietor can make an application and controller may register. Every application shall be in the prescribed form. What is the prescribed form? Form 1, you can write here in your material that every application has to be in the form 1 and it shall be filed in the patent office. Patent, I told you, patent and design office is same. Patent and same office is there for patent, same office is there for design. So you apply to the patent office. Same office is for design also. Are we clear with this? So you have to file an application in form 1 in the patent office, and who's the head of that patent office? He is known as controller. Okay, so every application shall be in the form 1 that will be filed to the patent office, and a design may be registered in not more than one class. This is very important. You can do this star mark. You know that design, a particular design, you can register in only one class. For example, I made a car. I made a unique design car. Okay, now I want to register this design for car. So I can register this design only for one class of product. Example, for car, for automobile category, for car category. For car category, I registered this design. So here one point is given, design may be registered in not more than one class, and in case of doubt as to class, who will decide which class you can register? Controller will decide. Matlab, if you're confused, let's say you made a bottle and you want to register the design of the bottle. So now that bottle will come under which category? If you're confused, then controller can help you. Controller can inform you, okay, that your design of the bottle will be registered under this particular class. But you can register design only in one class. Acha, if inside that class multiple article are there, can you register that in multiple article? Yes, you can register that in multiple article. Example, in the automobile category, you registered your design. Now, can you register your design for car also, for truck also, for pickup also, for similar categories? Are you understanding? Similar categories vehicle. Can you register that? Yes, you can do. You can register your design for multiple articles, but in the same class. Controller may refuse if any person is aggrieved, may appeal to High Court. Bakwas point is given here. Of course, it's not necessary for the controller to register only. So if we will apply to the controller for registration, controller can either accept or refuse. And if it refuses, you can appeal to High Court. Bakwas point. Application which owing to default or neglect has not been complied with shall be deemed to be abandoned. Bakwas point only if you don't comply with the objection of the controller, or your application is not complete, or your application is having default or defective application you're filing, your application will be abandoned if you don't, if your application is incomplete or faulty. Next, a design when registered shall be registered as on the date of the application. Here one point is given, that example, if I applied on 12th October 2023, on today's date, let's say 12th October 2023, I applied for design, but my design got registered on, let's say, 12th February 2024. In that case, my design will be registered effective from the date of application and not the date when it is when it is accepted, or not the date when it is actually registered. So even if a controller accepted my application on 12th Feb, then also my design will be deemed to be registered from the date of application, that is from 12th October 2023, the date when I applied for registration. Are we clear with this? With this, we are done with the process of registration of design. This section 6 is not very important. Okay, you can just see over it. You can see over it. Yes. Design may be registered in respect of any or all of the article comprised in a particular class of article. Here, please understand that you can register your design for a particular class. Now, inside that class, multiple article can come. So you can register your design for even one article or multiple articles also. Let's say I made a design of car. So I can register that design for car also, for small car also, mini car, for SUV also, for I can register that design for, let's say, छोटा हाथी also, for truck तो अलग हो जाएगा ना, for pickup also, for similar category. Are you understanding? So my dear, here one point is given, section number 6, which says that design can be registered for even one article or more than one article. You can register a design for one article or more than, let's say I made a shape of the bottle, I want to register that design, I can register that design for let's say bottle of the soft drink also, for bottle of water bottle also, I can register that design for water bottle also, for soft drink bottle also. So you can register a design for multiple article, but they should be belong to same class, they should belong to same class comprised in the prescribed class of the article. A question arising as to which class it will fall can be determined by the controller. Bakwas only. If you are doubtful that this product will come under which class, controller can help you tell, okay, your product will come under this class, water bottle will come under this class, car will come under this class. Controller can decide that. Next, here one point is given, language is thoda sa typical. I have written it in the easy language, that what do you mean by here. Here one point is given, that if you have already registered your design in one article, now further you want to register that design in another article, can you do so? Yes, I registered a shape of the bottle for soft drinky bottle. Now I want to register that shape of the bottle for water bottle also, or let's say for body lotion ki bottle also. Can I do that? Yes, I can do that by making a further application. Who can do that? Proprietor of the design. Proprietor means owner. So if I made a unique design, Coca-Cola is the owner of the design of the Coca-Cola bottle. So now if Coca-Cola is the proprietor of the design, can Coca-Cola apply to the patent design office and to register that same design for the water bottle also, or for any other bottle also? Are you understanding? So how you can do so? You can do so by making an application. Just because you have already registered that shape of the bottle for soft drink bottle doesn't mean that further you cannot apply and register that for water bottle. You can do so, you can definitely do so. Who can? Proprietor of the design can do so. So where an application has been registered in respect of any article comprised in a class of article. So if listen very carefully, huh? If you have already registered design is already registered in respect of any article. Let's say that shape is registered for Coca-Cola ki bottle. Are we clear with this? Any design is registered in respect of a particular article comprised in class of article. Yes, comprise in class of article. The application of the proprietor of the design, if you're further making application, who? Proprietor of the design. So the application of the proprietor to register in respect of some other article, to register that same design in respect of some other article, you are registering that same design for water bottle. Are we clear with this? To register that same design for some other article in that class only. Class is same, but you want to register that design for some other article, it shall not be refused. Controller cannot refuse that, controller has to register. So if Coca-Cola has already registered a design of the bottle for soft drink bottle, now Coca-Cola is applying to patent office or controller office for registering that same design for water bottle, then controller cannot refuse that. Controller cannot refuse that, they have to register. It shall not be refused, nor shall the registration be invalidated just because of the reason that it is previously registered, or just because of the reason that article has been previously registered. Here simply one point is given, just because of the reason that that design or that article is previously registered, it doesn't mean that we can further register it with respect to some other article of belonging to the same class. That's it. Fourth point you can ignore, or you can have a read. Similar point it is. Fourth point you can have a read. I hope this third point is clear to you. This third point is thoda sa technical, but I hope that this point is clear to you. This thing you can write for your self explanation, or you can take a screenshot, or you can write for your self explanation. This thing will help you understand. This is repeated You can have a read over this table. This is repeated. You can have a read. वैसे अच्छे points are given here short में. You can have a read over it. Repeated points are there. You can just have a read over it. Okay. Now come here. Section 7. Section 7, nothing. As soon as any design will be registered, that will be published. That will be published for public inspection, so that if any public has any objection, they can raise the objection. इतनी फुद्दू सी बात है. One liner section that controller shall, as soon as after the registration, even after the registration done, we will publish it in the prescribed manner, so that it will be open for public inspection. Simply one point is given: as soon as any design is registered, it will be published in official website for the public inspection, so that public can inspect, and if anyone has any objection, they can raise the objection. One liner section 7 khatam. Section 8 talks about joint application. We'll do at last, not important. Section 8 joint application. Can we make a joint application? क्या बता दूं क्या? हाथ की हाथ. चलो बता देते हैं. छोटा सा कर लेते हैं. Section 8 वैसे तो it should be given a separate heading. Like this is a proper separate heading. Substitution of applicant or joint applicant. For example, I made a design. Ishika madam, I made a design. I already made application to patent office. Patent and design office is same na. Okay, so let's say Ishika madam made a design, and I made a design with the help of Pinky and Preeti. With the help of Pinky and Preeti, I made a design, and I applied to patent office for registering of that design on my name. But later on, I want to change this, and I want to say patent office. Hey, patent office, listen now. What you do, don't register this design in my name only. Actually, I made this with the help of Preeti and Pinky. So what you do, please, you register this design in the joint name of Ishika madam, Preeti and Pinky, PP, IPP. Haha. Okay. So what can, is it possible? Yes, it is possible. It is definitely possible. So can you make a joint application? Yes. Can you later on make a joint application? Yes, you can do it. Earlier, let's say I applied only in my name. Now I want to change that, and I want to ask patent office. Hey, patent office, listen now. Please make it a joint application. Can we do so? Yes. Or can I transfer it? Yes, I can also transfer it. Let's say I applied for a registration of design to patent office on my name. Now I don't want to register it in my name. I want to get it registered in the name of Preeti. So can I transfer it? Can I assign it? Can I transfer the owner, or the person who is applying? Can the applicant be changed later on? Yes, applicant can be changed. Are we clear with this? That is the chotu sa topic. Very easy topic. You can have a read over it by yourself also. Substitution of applicant or joint claiming. Two topics are given here. One is substitution of applicant. Substitution matlab I am for the pehle I applied in my name. Earlier I applied in my name. Now I want to transfer it to Preeti's name. That is substitution. Joint claiming matlab earlier it was in my name only. Now we want to make it in the joint name of myself also, Preeti also, Pooja also, Pinky also. That will be joint claiming. Are we clear with this? So that is given in section 8, which says that name of the applicant can be substituted or joint claim. It can be substituted. Is it possible? Yes, definitely it is possible. Can it be done? Yes, it can be done. If the following requirements are met, some conditions are given there, you fulfill that condition and you can substitute the name. First is the claim is made before the design is registered. That substitution is done before the design is registered. Once the design is registered, after that you cannot do anything. But yes, application is made, application is pending, design is not yet registered, then you can do so. Number 2, right of the claimant. Let's say I am transferring my application of design to Pinky. So that Pinky's right can be created only by either assignment. Assignment means I am assigning my right to Pinky. Dusra, agreement in writing. I have entered into writing agreement with Pinky. Teesra, operation of law. Operation of law means a person died and then automatically that is being transferred to their legal heir. So only by this 3 means only you can transfer your right, either by assignment or by agreement or by operation of law. And the design shall be identified. Which design you want to transfer, that design has to be identified. This design, this shape of Coca-Cola bottle, this design I want to transfer. That design has to be identified properly. Design has to be identified which you are assigning. I am assigning to Pinky. Yes, and right of the claimant will be established by the court. Court will decide finally कि my right will be transferred to Pinky or not. And how you can make an application for substitution. In order to make an application for substitution, that application has to be in the form number 2. Matlab further, first I made an application to register a design in my name. Now I want to transfer it in Pinky's name. So I have to make another request, another application in the form number 2. Another application in the form number 2 to the controller. Yes, and will direct the controller to transfer it either in the name of claimant. Who is claimant here? Pinky. Pinky. Yes, to transfer it in the name of Pinky, or in the name of the claimant and the applicant, or the other joint applicant. Or you can say that, okay, please keep it in my name also and Pinky name also, my also and Pinky also. Matlab joint claimant. Okay, this thing you can do. That's it. That's more than enough, I guess. In case of joint application, controller shall not pass direction without the consent of other joint applicant. Bakwas point only. Ki let's say earlier now, we made a shape of the bottle. Now the shape of the bottle we want to register me and Pinky, Ishika ma'am and Pinky. We both applied to patent office for the registration of the shape. Now we want to add Preeti also. Now for that, earlier I and Pinky jointly applied for the registration of the shape. Now if we want to add someone else also, some more joint applicant, or we want to transfer it to someone else, in that case both of our consent is required. My consent is also required, Pinky's consent is also required, because earlier we filed this application jointly. Earlier, for the first time, me and Pinky, we filed this application jointly. So we both have equal right over this. Now if we want to transfer this right to someone else, to Preeti, in that case my consent will also be required, Pinky's consent will also be required. So here same point is given, that if we have made a joint application and we are transferring it to someone else, and controller will, before passing any order or before passing any direction, he will take consent of other joint applicant also. He cannot pass any order without the consent of other joint applicant also. In case the joint applicant dies at any time before it has been registered, a request may be made for the substitution by the survivor, and the controller may direct that the application shall proceed in the name of survivor alone. No such direction will be made without the consent of the legal representative of the deceased. Very easy. Let's take a small example. Very easy. A, B jointly applied for registration of a design. A and B jointly applied for the registration of design. Let's say B died. So can A register that in his name alone? Yes, he can. But B is legal here. Let's say junior Mr. B also has right to register that design in his name. So controller can register that design solely in the name of survivor Mr. A, only with the consent of junior Mr. B, that is legal representative of Mr. B. Are we clear with this? Otherwise, if he does not give consent, then that design has to register in the name of Mr. A also and junior Mr. B also, legal representative of Mr. B also. Are we clear with this? That's it. In case of any dispute, it will be decided by the court. You can leave this point. I guess that's more than enough. We have done section 8, that is about the joint applicant or transfer of the applicant. Next is certificate Fuddu, not very important. Ki whenever any design will be registered, then the controller will issue you a certificate of registration. That is very easy point. Section number 9. Section number 9 says that as soon as your design will be registered, then the controller will grant you a certificate of registration certificate of registration, and in case your original certificate is lost, you can get a duplicate, you can get a copy of the certificate, you can get a duplicate certificate as well. What is the effect of registration? Now this is important. Effect of registration of design. You know, when you register your design, you get copyright of design. Copyright matlab, this is not the normal copyright. Here copyright does not means that copyright book wala, painting wala copyright. No, here copyright means the exclusive right to use that design. Meaning, as soon as your design is registered, let's say I made a unique design of the bottle, and that unique design of the bottle is registered in my name. In that particular case, if that design is registered, what is the effect of registration? This is important. This can come in MCQ for 3 marks, sorry, in exam for 3 marks, 4 mark question they can ask you, what is the effect of registration? The effect of registration of design is that you get copyright with respect to that design. Now here copyright of design means you get exclusive right to use that design. No one else can use that design or apply that design in any article. Are you understanding? No one can actually make a bottle with the same design, because that design is my registered. I have a copyright on the design. Are you understanding? They here don't misunderstand this copyright with the normal copyright. Normal copyright is different. Here copyright means simply exclusive right to use the design. Are we clear with this? In the term used is copyright. So please understand, I hope you will not confuse it with the normal copyright thing. This is very important. What is the effect of registration of design? What is the effect of registration of design? The registration of design confers upon the registered proprietor copyright in the design. Meaning, registration of design means as soon as you register in design, it confers upon, means give to whom? To the proprietor. Proprietor means the owner of the design. He gives him what? The copyright in the design. Are we clear with this? So as soon as any design is registered, the proprietor get copyright over the design. Kya get? He get copyright over the design for the period of the registration, for the whole period of registration. What is the period of registration? 10 years. We will come to that also, but you will get a copyright, and copyright means the exclusive right to apply that design to any article. Here copyright means exclusive right to use that design in a particular article, belonging to class in which it is registered. Are we clear with this? So this is the effect of registration of design. Register of design, not very important. This is government requirement that every patent office may, they have to keep a separate register of design. This may they will mention the details of all the designs which are registered, along with the name of the owner, name of the proprietor, design details, etc. Very easy. Register of design, every patent office, that is government office, that is government patent and design office, has to maintain a book or registered called register of design. What we will write, of course, in that register we will maintain the all the registered design till now in India, and along with the name of the owner, name of the proprietor, owner of the proprietor, sorry, address of the proprietor, and design details. Are we clear with this? So wherein we will enter what? Name and address of the proprietor, register design, assignment, and if any assignment or transmission is done later on. Assignment and transmission means later on I transferred my design to someone else, so details of that assignment and transfer should also be there. And that can be maintained either in computer, floppies, or physical also. Meaning that design register you can maintain either physically also or electronically also, and mostly all the design, all these registers are maintained electronically only, available in the website of the IPR website, Indian IPR website, available. You for inspection, you can inspect also. So mostly government maintains this online only, मतलब computer में only, physical कौन maintain करेगा? Yes, most of the registers nowadays are maintained by government online only, computer के through only, मतलब digitally only. Are we clear with this? And this register will be prima facie evidence that yeah, that design is registered in your name, but it is not conclusive evidence. Only prima facie evidence, not conclusive evidence. मतलब it can be countered. Are we clear with this? That is small point about register of design. Copyright may for how many years you get copyright registration? You can write here 10 years plus 5 years extension. That's it. Maximum 15 years. patent can be registered, sorry, patent nahi, I'm really sorry, design, maximum 15 years, maximum 15 years. You can write here your design can be registered for 10 years, and then when your 10 years will about to expire, you can get extension for next 5 years. Total of 15 years your design can be registered. Your design can be registered for 15 years. So you can come here once design is registered. uh, Give me a second, I need to charge my device. Give me a second, and I'll give you you have to read this para in your book, page number 124. Read this para. I'm coming in 2 minutes. 2 minutes ka break, 2 minutes ka break. Read this paragraph. I'm coming. We are about to be done with the chapter. Last 2 pages are left, which are very easy. Not to worry, we are about to complete this chapter. Okay, 2 minutes break. Yes, yes, yes. So we can continue. It is charged 5%. Enough to continue with the classes. Okay. I hope till now it is easy. Till now it is pretty easy, and till now it is understandable. Uh, what is what is design? Okay. Yes. Please come to page number 124. Have you read this topic? Have you read this para? This para I asked you to read. Yes. Have you read this para? Have you read this para? This particular para I asked you to read. Yes, guys. Anyone read kya? Very easy. वैसे it is copyright on registration. For how long you get copyright protection? For design, you get it for 10 years plus 5-year extension you can get. Now, what is the difference between the normal copyright and the design protection? If you remember, you can make this small difference table in your notebook. What is the difference between the copyright and the design protection? Copyright may you get protection for 60 plus years after death. 60 plus year after death, matlab how long? 60 years after that. But design may you get only maximum 15 years protection, that is 10 years plus 5 years. So obviously copyright registration is better than design if possible to get copyright registration. Are we clear with this? So copyright registration is done for 60 years after death. Matlab, if you remember, remember kya patent registration was for 20 years. Remember kya trade patent for 10 years, trademark for 20 years, copyright for 60 years, and design for 10 years plus 5 years. Remember kya? Remember kya? Oh my dear, remember kya? We have done the tenure or the term of the registration of all this: patent, trademark, copyright, design ka it is 10 plus 5 years. Are we clear with this? Yes. So design may here you can write 10 years plus 5-year extension. That design may be registered for 10 years, for 10 years, for 10 years, and that means that you will get protection, you will get copyright for that design for 10 years. Are we clear with this? Now here copyright, please, I am telling you again, please don't confuse here. Copyright does not mean that copyright. Here copyright means the exclusive right to use the design. So when a design is registered, the registered proprietor shall have the copyright in that design during the 10 years from which date? From the date of the registration. Now before the expiry of the 10 years you can apply for extension, and controller can give you extension for another period of 5 years from the expiry of 10 years, which means what is your tenure of design, copyright of design? 10 years plus 5 years, that is maximum 15 years. Please don't confuse here. We are not talking about the tenure of copyright. Tenure of copyright under Copyright Act is 60 years after death. If you remember, if you write a book, your book will be copyrighted in your name for 60 years after your death. That is different. Here we are talking about copyright of design. Copyright of design is given only for 15 years. 10 years after, now before expiry of 10 year you can apply for extension, and extension you can get for next 5 years. So total of 15 years. Are we clear with this? Yes. After that this para is not very important. You can just have a read over it. You can just have a read over it. This paragraph is not very important. Following guidelines for copyright. Guidelines to copyright. It's 8. मैंने सोचा था, I thought कि 8 तक we will complete. We have almost completed. इसको मैं last में I will read. First come to other topic. Others are lappu topics. Lappu topics are left. This we will read at last. Bakwas is given here, very normal points. Come here. Restoration of lapsed design. What if your design is lapsed because of the because of any reason? If your design is lapsed, then you can apply for the extension. You can apply for the extension in the form 4. If it is lapsed because of non-payment of fees, because of non-payment of fees. So you can write here, if because of the non-payment of fees your design is lapsed, meaning government said you have not paid the fees you have not paid the fees for extension, your design is lapsed, now we are no more giving you the protection. In that particular case, you can apply again in form number 4 to get to renew your design, restore your design, restore your design. But that application, if you make that application after 3 years, chalega kya? No, that application has to be made within 1 year from the date on which the design has ceased to take effect. Now let's say after 10 years I can get extension, right? So let's say after 10 years now I did not pay extension fees, I did not get it extended, so my design is lapsed. Now after my design is lapsed, 1 year time I have, within 1 year what I can do, I can further file a form 4, I can apply to government patent office, and I can get my design restored. Are we clear with this? Very lappu sa topic ki design which is having effect, which ceased to take effect by the reason of failure of payment of fees for extension. You did not pay fees for extension, because of that reason your design has ceased to take effect. In that particular case, proprietor or the legal representative, either the proprietor of the design or the legal representative, may within 1 year from the date when it is left make an application in form 4 for the restoration of design, and then controller may on application allow the restoration of the design. That's it. An application shall contain the statement verified setting out the circumstances which led to the failure of the payment, and the controller may require any further evidence. When you will make an application, in that application you have to make a statement also. In that statement you have to give the reason that why you failed to make the payment. You have to give the reason, and if controller want, they can want any other evidence also. Bakwas si baat hai. Small topic about restoration of lapsed design. One line mein I will revise. If you don't pay the fees, because of that your patent is your design is lapsed. So further within 1 year of the lapse, you can apply in form 4 to restore your design. That's it. That's it. Chotu sa, chindu sa, lappu sa baat hai. With this we are done with this. Next is, can the registration be cancelled? Acha, can patent office can cancel the registration? Can they cancel the registration? The answer is yes. According to section 69, registration can also be cancelled if this 5 situations are there. Are you understanding everything till now? Please give me a message in the chat box, everyone. Give me a message in the chat box if till now, if it is clear to you. Till now, if it is clear to you, give me a message in the chat box. Yes. Yes, till now it is clear. Easy chapter, right? Amulya, Shushma is saying yes. What about others? Chandana, Pinky, and Preeti. Give me a message in the chat box. Yes. Okay, great. So last few topics after this chapter is done. Chotu sa topic, lappu sa topic. Guys, if let's say you don't comply with the law, or your design is not original, or your design is offensive, or it is not registrable for any reason, for any of this reason, government can, that is patent office or the controller of patent, can cancel your design. So registration of design can be cancelled on the following grounds. On which grounds registration can be cancelled? Registration can be cancelled if, number 1, that design is already registered. So they will cancel your registration saying that this design is already registered. If that design is published in India or elsewhere, that design is already published either in India or outside India, that is not your original design, that design is already published, that design is not new or original, that is not your new design or original design, you have copied someone else's design, that design is not registrable for any reason, or that is not even a design. It is not even a design, it does not fall under the definition of design under section 2 clause D, right? So if for this 5 reasons are there, then a controller will not register your design, they will cancel your registration of the design for this 5 reasons, which are very lappu. This can comes for 4 mark or 5 mark, the reason grounds on which the registration can be cancelled. Next, design to bind government. Here simply one point is given, that remember we studied in patent that patent can be purchased by government, or patent can be used by government for public interest. If it is for public interest, then government can use a patent. But you know what, design government cannot use. Government is also bound by the design registration. A patent may, for public welfare, if that design invention is necessary to be used, then government can use that invention. Are you understanding? But design may, government cannot use design except for only one exception is there. Except for that, government cannot use design, which means government is also bound by the Design Act. So here a registered design shall have intent like effect as against the government as it has any other person, which means government cannot use, or you can say government cannot access or use design without consent of proprietor, without consent of proprietor of designs, which means government is also bound by the designs under design law. That's it. Very important. Make a lot of star marks here. Make a lot of star marks here. Lot of star, moon, lot of star, moon, etc. Very important. Piracy of registered design. Piracy of registered design. What do you mean by piracy? Piracy means copying. Piracy means copying. When very example, Chandni Chowk, Delhi ka Chandni Chowk is the very good example of your piracy of design. वहाँ सब चीज का डी मिलेगा आपको. In Delhi ka Chandni Chowk, you will get duplicate first copy, second copy of all brands, every single brand. Yes, Zara ka bag you will get. Yes, everything. So that is known as piracy of design. Piracy means copying someone's design, selling it, or publishing it publicly. That is known as piracy of design. Piracy means copying someone's design without their permission. And this is very important topic. This can definitely come in exam from this topic. Piracy of design. What do you mean by piracy of design? Piracy means either you are publishing that particular design or article, or you are selling it for making profit. You are selling the you are selling that design, making that same design or using that same design in an article, selling it, making an illegal profit. All this thing can come under piracy of registered design. Very important topic. Make it a star mark. बहुत सारा star and moon, very important. Piracy of registered design. So 3 things can come under piracy. Point number 1, point number 2, and point number 3. The 3 points. If this question comes on piracy of design, then these 3 points you have to write. Are we clear with this? Number 1 here, during the existence of the copyright in design. Copyright in design here does not means copyright. Here means exclusive right to use the design. I hope you are clear that by now you understood and you will not confuse between the meaning of copyright and copyright in design. Are we clear with this? I hope you will not confuse with these two terms, right? So during the existence of the copyright in the design, it shall not be lawful for any person without the license or the consent of the proprietor to do these 3 things. These 3 things will be considered as piracy only if it is done without the consent of the proprietor. So if you do these 3 things without the license or without the consent of the proprietor, then it will be considered as piracy of registered design. Now what are these 3 things? Point number 1, if you are using the design for the purpose of sale, to apply or cause to be applied to an article in any class of the article, if you are applying that design in the article to sell that article. For example, you are copying Sabyasachi design, you are making a similar lehenga, you made a lehenga by copying the same Sabyasachi ka design, and now you are selling it. Now you are selling it in Chandni Chowk. That will be called as piracy of registered design. Are we clear with this? For the purpose of sale, what you are doing, you are applying that design to a particular article. You are applying that design to a lehenga, to a product. You are applying that design to an article for the purpose of sale. This is called as piracy of design. Number 2, you are importing such article for the purpose of sale. Again, you are importing that article from outside India for selling in India. You are importing without permission. Illegal import, smuggling we call it. Yes, illegal. You are importing that article without permission, without license, you did not have license. Yes, you are importing that article for the purpose of sale in India. Sorry. You are importing that article for the purpose of sale in India. That will be also called as piracy of registered design. Third, to publish or to expose for or cause to be published or exposed for sale that article. You are publishing that article for sale. Let's say you made a website, and in that website all duplicate products are there, all duplicate, to copy, same copy of Louis Vuitton, same copy of Gucci. Yes, all the duplicate copied products you are publishing for the purpose of sale. That is also called as piracy of registered design, that is to publish or expose or cause to be published for the purpose of sale that article. That article, are we clear with this? Yes, article means the product in which you are using that same design. Are we clear with this? Are we clear with this? So if let's say you are making a same design of shoes, so that shoes will be called as article in which you are copying the design. So these three things are known as piracy of registered design. Number one, for the purpose of sale, you are applying that design to an article. Number two, you are importing that article for the purpose of resale, or you are publishing it to the public for the purpose of sale. Are we clear with this? Yes, yes, yes. With this we are done with piracy of registered design. Same thing is given here. What is piracy? Repeated. You can just have a read repeated. What is piracy of registered design? Next is appeal. Last topic is appeal. After this chapter is completed, congratulations. So I told you 2 hours may we will complete, and 2 hours may be completed. Yes. Appeal. Here one point is given that simply you can if controller refuse to register your registration, or refuse to restore your patent or anything, if controller refuse to register, or pass a cancellation petition, cancels your registration, or orders you to rectify your registration, or refuse registration on the grounds of public morality. If for any reason, if controller refuse to register, or cancel your registration, in that particular case you can file an appeal to high court. That appeal can be made within 3 months, and high court can obtain assistance of export also. Decision of high court will be final, which means if high court also orders against, also cancels your registration, you cannot file further appeal to Supreme Court. So appeal to Supreme Court is not allowed. Judgment of high court is full and final here. Simply one thing, appeal to high court, chhapri sa point, lappu sa point. If controller rejects your application, you can file an appeal to high court within how much time? Within 3 months. And high court can take the assistance of the expert also. And lastly, decision of high court will be final. That's it. With this we are done with chapter. Two chotu point is left. One is your industrial and international exhibition, not very important. You can just have a read over it. Here one point is given that if you are showing exhibitions, lot of exhibitions are there now, industrial exhibitions, yes, public exhibitions are there. So what if you are showing the design, or you are publishing the design, you are showing that design in an exhibition, will that be allowed? So here one point is given that exhibition of design or any article in which that design is there. So exhibition of any design or article to which the design is applied at an industrial or other exhibition, to which such provision, to which the provision of this section has been extended by the central government or by any other person. So if central government or any other person is doing exhibition of any article without the consent of the proprietor, it shall not prevent the design from being registered or invalidate the registration. Simple one point. Once again I will repeat here what is given here. Let's say I made a design and I am the proprietor of that design. Let's say I made a unique design of pencil and I am the owner, because I made this design, so I am the owner of this design. I have applied to controller of patent for registering this design. Okay, I have already applied. Meanwhile, what happened? Central government did one exhibition. In that exhibition, they showed the same design. They showed same design, published my design in that exhibition. Does it mean that controller will reject my registration? No. Just because my design is shown in exhibition either by central government or by any other person, it doesn't mean that they will cancel my registration. No, they cannot cancel my registration on this ground, just because it is shown in exhibition, provided one condition is there, that exhibitor has to take give me, inform me that I am exhibiting your particular design in this exhibition. And number two, the application for registration has to be made within 6 months from the date of exhibition. Even if, let's say, my product is shown in exhibition, now I want to get it registered. Can I register? Yes, provided one timeline is given of 6 months, that I have to apply to the controller. I have to apply to the controller to register my design within 6 months from the date of exhibition. When it was shown in exhibition, within 6 months from that date, I have to apply to the controller for registering that particular patent. Please come here. Exhibition of design, industrial and international exhibition. Once again, you can read along with me that if there is any exhibition of any design, or the article in which the design is applied in any exhibition by either central government or by any person elsewhere, yes, by any person, without the consent of the proprietor, without the consent or without the permission of the proprietor, without the permission of the real person who made the design, it will not prevent the design from being registered or invalidate the registration. It will not invalidate the registration if it is already done, and if registration is not done, then it cannot prevent the design from getting registered. Even if after the exhibition also, if I want to register that design on my name, I can register, because I am the rightful proprietor. Even if that is used by central government in exhibition, then also it does not prevent me from registering that design in my name, provided two conditions are there. That exhibitor has to give me a notice. Point number one, exhibitor exhibiting gives notice, gives a notice to the controller. That exhibitor has to give a notice to the controller that we are showing this particular product in exhibition. And point number two, that application, if I have not yet registered that particular design in my name, then I have to make an application for registration within 6 months from the date of exhibition. Within 6 months from the date of exhibition. Small point, not in very detail, that is more than sufficient. You just read, if any exhibition is done by any person, it does not prevent from registration or does not invalidate the registration. Two condition, notice has to be given to the controller, and number two, registration application has to be made within 6 months from the date of exhibition. That's it. Itna hi you have to study. Don't try to go beyond this. Don't try to go in too much detail or too much lengthy. Itna what is given in the material. Even if let's say question from this comes for 4 mark or 5 mark or 3 mark, you will be able to write it pretty much enough. दिस टॉपिक इज मोर देन इनफ. तो इतना ही रीड ओनली इतना, इससे ज़्यादा कुछ नहीं, इससे कम कुछ नहीं. Are we clear with this? With this, we are done with this chapter. We are done with this chapter. Last topic, small topic na. We basic point is given here. We have already covered this. High Court in one case gave the following guidelines. Not very important. Should I leave this? Can you read this? चलो एक दो लाइन लेट मी रीड दिस. नॉट वेरी इंपॉर्टेंट. यू कैन मेक अ लाइन हियर. कॉपीराइट वाला टॉपिक इतना ही था. कॉपीराइट ऑन रजिस्ट्रेशन वाला टॉपिक इतना ही था. टर्म वाला ओनली दिस मच इट इज. टर्म वाला टॉपिक only this much is the term wala topic, that is 10 years plus 5 years 15 years. That's it. From here now another topic is there. In some case, High Court has given some guidelines. In some case of Microfibers Incorporation versus Girdhar and Company, in this particular case, High Court has given some guidelines. That guidelines is given here. Not very important. You can just have a read over it. Like let's read few of the guidelines. Guideline number 1, the definition of artistic work is very wide connotation. Okay. And in no circumstances by any limitation of the work processing, even an abstract work such as a few lines or curves arbitrarily drawn would qualify as an artistic work. It may be 2D or 3D. It may not have a visual appeal. Artistic work, here the definition of artistic work is given here. Any artistic work you make, even few curves or few lines you make, that will be called as artistic work. But artistic work mein you get copyright protection, you don't get design protection. Artistic work में we have studied, it does not come under design law. Artistic work के लिए you can get copyright, हाँ, artistic work के लिए you can get copyright protection but not design protection. What is it is the exclusive right of the holder of copyright in an artistic work to reproduce the material form. The design protection in case of registered work cannot be extended to include copyright protection. This point is important. D wala point पढ़ लेना. Please read this D wala point. That if you take design protection, it doesn't mean that you get copyright protection. No, if you get design protection, you cannot get copyright protection. If you get copyright protection, you cannot get design protection, except for some article. Some article के लिए exception is given. Only for few articles exception is given. Except for the exception part, generally you cannot get design protection and copyright protection for the same article or for the same design. Either you can get design protection under design law, or you can get copyright protection under copyright law. That point is given in point number D. That too, the design protection in case of registered work cannot be extended to include copyright protection. Design protection cannot be extended to copyright protection. You are getting design protection. It does not mean that you are getting copyright protection under copyright law as well. I have told you multiple times, you can either get design protection or you can get copyright protection. You cannot get both the protection for the same article. Right? That's it. If a design is registered under Design Act, if you are registering any design under Design Act, the design would lose its copyright protection. Wow, kya line, must line, very nice line is given here. This line also you can study. What is given here, I'm telling you. Let's say I made a unique design, I registered it under copyright law. Okay, now this is registered under copyright law. Later on I registered that same design under design law. So what will be the effect of registering that design under design law? The effect will be कि automatically copyright registration will end. Meaning, if you register that under design law, copyright registration will end. You cannot get design protection and copyright protection at the same time. These 2 points are similar. If design is registered under Design Act, it would lose its copyright protection under Copyright Act. Are we clear with this? Yes, these things we have already taken. That's it. This remaining points now, you can just have a read over it. Right to which holder of the original work and tales are enumerated. You can cut this point. That's it. First point we have already done. Other points you can just have a read over it. Not very important. We are done with this. This is repeated. This table is repeated, and with this we are done with the design chapter. I'll just quickly show you what we have studied in this chapter. Pehle to we studied some introduction which is not relevant from examination point of view. We did purpose of the design law, one liner. Definition of design is very important. Definition of design that we studied. After that, proprietor of design, number 1 author, number 2 the person for whom you are making it for consideration, and number 3 the one person to whom it is transferred or assigned. Prohibition, 4 types of design cannot be registered: which is not new or original, which is already disclosed to public, which is not distinguishable, and which is obscene or scandalous. Okay. After that we did process of registration. This table, process, make an application, they will do the examination and all. If no objection, they will register. If objection is there, hearing will be done. Bakwas. Then joint application can also be done. It can also be assigned in the name of someone else. After that we did as soon as my design will register, they will publish it in the website for the public inspection. Yes, that's it. They will give me a certificate of registration and enter all the details in the register of the design maintained by the design office, government. Design is protected for 10 years plus 5 years extension. You can get total 15 years. That's it. This bakwas point. Your design can be registered either under Design Act or under Copyright Act. You cannot get both the protection at the same time. Then we did, in case you fail to pay the fees and your design is lapsed, within 1 year you can apply in form number 4 and you can restore your design. Controller can cancel your design for this 5 reasons. Next, government is also bound by your design, which means government cannot copy your design even for public welfare. Piracy of design, very important. Piracy means copying the design without the license or without the consent of the owner. When you are either reselling your, for the purpose of sale, you are applying that design to any article, you are importing that article for resale, or you are publishing that article for the purpose of sale. Lastly, exhibition wala bakwas point was there, and lastly, appeal to high court. Appeal to high court can be done within 3 months. That's it. In 5 minutes I revised the whole chapter. This chapter is not at all a headache. If you want first time study mein, to it takes time. So first time it took 22 hours. Revision mein, first time you will study mein, one hour mein you can study everything by heart, everything, memorize everything. For multiple revision, one day before exam, you can revise this chapter in 15 minutes, in 10 to 15 minutes, maximum 10-15 minutes, one day before exam. One day before exam you can revise this chapter in 10-15 minutes. Don't give more time than that. First time reading may you might take an hour or so to by heart all the points properly, to by heart some legal words, some legal language. Otherwise the chapter is very easy. Only you have to study how much you have studied. These questions are very phuddu. You can go through it. Yes, any doubt, or we can sum up our today's session. Any doubt? Any doubt? No doubt, no doubt, no doubt. With this, we are done with the design law. With this, we are done with the design law chapter. Tomorrow's timing will be changed thodu sa. Tomorrow, I might not be able to take lecture. In that particular case, our next lecture will be after your GST. After your GST lectures, I'll just quickly ask for how many days you will have GST lectures. Yes, I guess GST is from day after tomorrow, no? GST class is there from day after tomorrow, no? Yes, yes. So after your GST class, I'll be taking few more sessions, small sessions. It will be not a five hours lecture. Either it will be 2 hours, 2.5 hours, or 3 hours lectures maximum. We are done with design. Remaining topic now, I'll complete all at once. I'll take one lecture, and in that one lecture, we are done with design. I'll take one lecture. In that one lecture, I'll be completing with GI also, trademark ka one topic also, patent ka one topic also. With that, we'll be done with part 2. And then we'll take one chotu sa lecture, and we'll take fugitive economic offenders wala topic, hardly 10 pager. It is also hardly 10 pages, right? So we'll be doing that. So we'll be needing 2 more lectures to complete the course. One lecture for this GI, and one lecture for economic offenders, right? So with this, we are ending our today's session. Thank you so much for giving your time and for attending the session. I hope that this is beneficial for you and you understood what is design and how to study this chodu sa chindu sa pyara sa chapter. With this, we are ending our today's session. In case of any doubt, you can post it in the Telegram. I will surely clear your doubts. Yes. Tomorrow's timing I'll inform. Tomorrow whether there will be lecture or not, I'll inform in the group. Yes. I'll keep you informed in the Telegram group. Do check Telegram group for information. Okay. In case of any doubt, surely ask me. Keep on revising. Keep on revising. Revision is the key to success. Keep on revising. Keep on revising. So that's it. With this, we are ending our today's session. Take care. See you tomorrow, or another day. See you. Take care. Bye bye.